Item 2.
2 minutes. With consent of all the party, my lord, may I pray that this matter be listed after 3 weeks, my lord.
For 3 weeks.
3 weeks, my lord. Pardon, my lord. Item number 8, my lord.
8.
My lord. I'm informed, my lord, learned special PP is not here, my lord, out of station, my lord. So so I pray that this matter be listed after.
Petitioner. You're for
I'm
the
board petitioner, my lord, listed after 2 weeks, my lord.
Okay.
In both the case, I'm board of petitioner, my lord.
The other side.
Other side, my lord. My lord,
Special
Opada,
After
2 weeks, my lord.
2 weeks.
8. Pardon, my lord. I beg to my lord mention 2 anticipative bail application unlisted 2 anticipative bail application, my lord, arising out of same
Listing.
FIR, my lord.
Listing.
Listing for listing. Today, my lord.
Okay.
My lord, I humbly pray, my lord, the applicant, my lord, is a government employee, my lord. So I pray that let be list 2, my lord, if time for him. Obviously, highly.
May I please, ma'am?
Yes, please.
My lord, I beg to mention item number 3, ma'am.
3.
Yes, ma'am. I am court respondent here.
You're for the respondent.
Yes.
The petitioner.
My lord, the petitioner counsel informed me that he will absent today, ma'am. Matter may be taken after 3 weeks, ma'am.
You're Mr.
M. Dozy, ma'am. My lord, item number 10 also, ma'am.
10.
Yes, ma'am. Same counsel.
Same party.
Yes, ma'am.
2 weeks.
Taken after 3 weeks, ma'am.
3 weeks. Sir.
Yes.
3 weeks.
Of
With the
last.
consent of the other side. eh? Yes.
My lord, I beg to mention item number 9 on behalf of N. Ratan for the petitioner.
M.
N. Ratan, Ninong Ratan, AAG. Matter may listed after 2 weeks. He is out of the station. I have taken consent from the other party also.
Other parties, you have taken consent.
Yes.
You're for the other side.
Yes, ma'am.
You're Mr.
P. Harming.
and Ratan. Taken consent of the other side. 2 weeks.
Much obliged.
Of last.
May I please, your lordship? Your lordship, I beg to mention item number 6 on behalf of Mr. D. Kamduk. He instructed me to seek some more time to file rejoinder, your honor, your lordship. Matter may be listed after 3 weeks. yes.
May I please, my lord? My lord, this matter, item number 6 is civil revision petitions.
Civil revision.
Civil revision. So this matter is not lies before this honorable court because already Arunachal Pradesh Civil Act has enacted and direction has been clearly given in the provisions. If any decisions in the village level, so that has to be appealed before the civil judge, junior division or district judge. So here matter is filed under section 227 is not lies before this honor.
Doesn't lie. Yes.
Only to dispose of the matter.
I can dispose of the matter, no problem.
But
Yes, please.
but leading counsel is not here, your lordship.
Who's your concern?
Dugmal Kamduk, your lordship.
You can take up the matter tomorrow, day after tomorrow.
My lord, I am here, but
Yes.
Uh,
you're here.
here we need to file a reply to the filed by the respondent. There is in fact,
File objection.
Yes, my lord.
Yes.
I have already filed objections.
You can file reply also.
yes, I'll file a reply also. For that I need some time. Can the matter be listed after this break because we have a break on
Monday?
October? Yes, not
Monday,
Monday, not Monday, my lord. After the break.
During this period, you can file a reply. You can fix up the matter on Monday.
Monday, no,
Monday means, what is the date?
18 months.
18.
Monday it won't be possible also.
Not possible.
At least 2 weeks may be given.
2 weeks.
Yes,
Then 1 week.
it's 1 week.
Granted counsel for the petition is for 1 week time to file a reply in objection filed by the Opposite respondent. Yes, date please. 21/9 for filing of objection, and after that we can take up the matter.
Yes, Lordship.
All lines met.
If I may, Your Lordship, I beg to mention item number 12 with 13. The conducting counsel, Mr. Kitama, for due to some personal difficulties, he is not available today, Your Lordship.
This is criminal LP, criminal leave application.
Yes, Lord, Your
What's
Lordship.
the problem to dispose of the matter?
Your Lordship, that the conducting counsel
Wait for
has
some time.
directed. Okay, Your Lordship, oblige.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 11. Your Lordship, I have taken consent from the other party also.
You're for the
Respondent, Your Lordship.
respondent.
Yes, Your Lordship. Your Lordship, conducting counsel is out of station due to some personal
Who is out of
difficulties.
Station.
Conducting counsel, Your Lordship. P. Thafo.
We,
P. Thafo.
his name is not there. Oh,
You're
Peter,
also-
oh, yes, yes, yes. You're for the respondent.
Yes, Your Lordship.
Yes, you're for the
Yeah.
petitioner. You're ready to argue the matter. It's
Lordship,
an 18 matter.
yes, Lordship, but my senior colleague.
Okay, on Monday, we can take up the matter on Monday.
Your Lordship,
Yes,
we have submitted the letter of absence till Monday, Your Lordship.
till Monday, then
Maybe after a week, Your Lordship,
after
then,
week.
yes, Your Lordship.
Okay, 21.
Okay, much obliged, Your Lordship.
Interim order may be confirmed.
Yes, please.
Interim order may be confirmed.
Okay.
Much obliged.
Item? One, what about one? One? Okay.
In a 14 says, usually the 14 is in something. Possibly it is in the supplementary list, that is why. But Your Lordship. Well, this revision is directed against an order. Against an order passed, I'm just giving the background, then I'll come to the impugn order. It is against an order whereby the impugn order is at page 121. In a summary suit, my lord, we are the defendant. In fact, I'm the only person defendant.
121, yes.
Yes,
Money suit.
yes. The money suit was filed in the form of a summary suit. Your lordship is aware that under 37, in certain cases for early disposal, a summary suit can be filed, where there is not much is required to be decided by adduction of evidence, etc. Then summary suit is filed for early disposal, for early relief. Now, in this case, when the summary suit was filed, we filed an application under Order 7, Rule 11 for rejection of the plaint on the ground that if a regular suit is filed and regular suit is pursued, we have got no objection, we will contest. But summary suit will not lie in this case.
You were
Pri-
the defendant there.
I was the
Money suit.
defendant. I was the sole defendant there. We filed the application, in fact, solely on the ground there for filing a summary suit under Order 37. Lordship, may I kindly have a look at page Order 37 once before I go to the order, madam. Just one point.
Please.
Order 37, possibly in that book, it will be page 205. Lordship.
205.
205, possibly, because page numbers may differ from book to book. Order 37. Lord, yes. Now, it says summary procedure,
37,
Order 37,
27,
Order 37.
37, yes.
Yes. Courts and classes of suits to which the order is to apply. This order shall apply to the following courts, namely A, High Court, Lordship, in some states, the High Court has original jurisdiction like Calcutta High Court, Bombay High Court. So that is why High Court is mentioned here. City civil courts, courts of small courts, and other courts, B, provided, etc. This A and B we can skip. This speaks about the courts to which the suit will lie. We are not concerned with that. Sub-rule 2, Lordship may kindly say, this is important. Subject to the provisions of sub-rule 1, the order, that means the order 37 for summary suit, applies to the following classes of suits, namely A, suits upon bills of exchange, hundis, and promissory notes. B, suits in which the plaintiff seeks only to recover a debt or liquidated demand in money payable by the defendant with or without interest, arising 1, on a written contract, 2, on an enactment where the sum sought to be recovered is a fixed sum of money or in the nature of a debt other than a penalty, or on a guarantee where the claim against the principal is in respect of a debt or liquidated demand only, and 4th, suit for recovery of receivables instituted by any assignee of a receivable. Lordship has seen that summary suit can be filed in respect of cases where these apply, A and B. A says there has to be bill of exchange or a hundis or promissory note. B says there has to be contract either or enactment or a guarantee or for recovery of receivables instituted by any assignee of a receivable. In the present case, what has happened? The background facts are like this, Lordship, that a particular plot of land was acquired by the government for construction of road by the ITBP. NHIDC, by the NHIDC. Now, for construction of the road, a plot of land was required to be acquired. So, land was acquired through a land acquisition proceeding. And then, Lordship, the compensation was determined. Possibly 24 crore was the amount decided to be the amount of compensation. Now, it was found that in course of proceeding, there was a writ petition, there was a civil suit. It was found in the proceeding that the compensation was to be paid to a particular clan called Saji clan. Now, Saji clan is again divided into 2 sub-clans. One is Jenpen and the other one is Jandu. Now, so far as Jandu clan is concerned, they have got no grievance. They are not parties here. They have received their compensation. It is the some of the members of the Jenpen clan who have come with this summary suit before the trial court. Now, their contention is that an amount was fixed for compensation. The person who has received the compensation on our behalf by virtue of a power of attorney, he has not paid us the compensation. Now, here the certain questions will come. First of all, this type of case will not follow any of the categories mentioned in sub-rule 2 of Order 37, Rule 1. Now, in course of argument, my learned friends were present there. I was not present in Along. My learned friend argued the case. The respondent appearing for the plaintiff who was opposing our application has referred to Order 37, Rule 2, Rule 1, Sub-rule 2, Clause D, Lordship. Clause 4. It's not very much mentioned here. I will come to that impugn order later on, Lordship. Clause 4 says, suit for, Lordship may kindly have once again, page 205.
Clause 4.
4 says, suit for recovery of receivables instituted by any assignee of a receivable. Now, interestingly, possibly learned counsel, my friend appearing there for the plaintiff, wanted to say, let's see, by executing a power of attorney, the members of the clan given you the right to receive the compensation. And that is how he wanted to come within this. But if we read properly this particular clause, it says, suit for recovery of receivables, this much is all right, instituted by any assignee of a receivable. That means, your Lordship is aware, assignment means transfer. Supposing A is to receive something and he makes an assignment. and he transfers the right to receive. And this suit is instituted by the assignee. He even assuming that he comes, although there is no contract of assignment, assuming that he comes within this meaning of this assignment here, even then it is the assignee who has to institute the suit. Now, if there was any assignment in his favor, the assigner cannot. You are saying that you have assigned. That means you are an assigner. You cannot institute the suit. Even otherwise, assignment contract is not there. It is not a case of assignment.
There is no any contract.
No contract. That is why in the beginning itself says on a written contract. Lordship is aware this scheme of this order 37, whereby the parties litigants are given the right to institute a summary suit, so that supposing there is a written contract, C, A has to pay 20 rupees to B, then B doesn't pay, nothing else is decided, required to be decided. Only thing required to be decided whether he has paid the amount or not. In those cases, a summary suit is allowed to be filed. Here is a case, Lordship. Now, what has happened? There are 31 persons who have come. Lordship will kindly see. I'll come to the facts. I'm just giving the background. 76 families are there in the Genpen clan. 76 families. So each family will get 1/76 out of the 12 crore. Now, in this case, what has happened? There are persons who have come before the learned trial court, 4 or 5 persons from one particular family. So all of them will not get one share. 4 of them will jointly get one share. This is to be decided in a regular suit. This was our contention number 1. Secondly, for last 10 years, there were litigations in the Supreme Court, litigation in the High Court, litigation in the Civil Court. For this, a power of attorney was executed in favor of the present petitioner, Lordship.
Then head of the family, he can receive.
Yes, head of the family can receive, but that head of the family will receive only one share.
You have to identify first.
I'll have to identify. I'm not on that. What I'm saying today is, if a summary suit has to be filed, it has to come within the meaning of Order 37, Rule 1, Sub-Rule 2.
Yes.
Now, Lordship will come to the impugned order, whether there is any discussion, because our specific plea is this doesn't come within the meaning of Order 37. We have annexed our petition also. Lordship may kindly have a look at the petition first. Page 110 is our petition. Now,
110.
110 is start, but first few pages are only names of the parties. 117, Lordship may state we go. There is a small petition. 117. Just 2 paragraphs I'll read, Lordship.
7.
Yes. Paragraph 4. That the petitioner beg to state that from the bare reading of the provisions of Order 37, Rule 2 of the Civil Procedure Code, it is evident that the instant suit seeking payment of compensation, simpliciter, without there being any of the eventualities mentioned in Sub-Rule 2 of Order 37, Rule 1, would not be filed as a summary suit, as the same does not fall in any of the classes mentioned therein. Number 4, paragraph 5, second contention. The petitioners beg to state that the instant suit is not a case for recovery of debt, and there is no contract binding upon the applicants to make any such payment to the defendants. The defendants are merely claiming the compensation amount based on some RTI applications filed by them, and do not have any knowledge about the actual payment of compensation amount made by the applicants to the beneficiary households of the Genpen clan. Moreover, the plaintiffs have not been able to come up with any clear picture of their claim, much less with any specific claim that their case falls in any of the categories mentioned in Sub-Rule 2 of Order 37, Rule 1, Civil Procedure Code. Lordship, I will not read any further paragraph. Now, straightway, I will show just one particular paragraph from the plaint. One particular paragraph.
Yes.
Now, Lordship, may kindly turn to page 23. The plaint starts from page
23.
23. Yes. Now it starts from page 23. I am taking your lordship to paragraph 15 at page 26.
Para 15.
Para 15. There, para 15, at page 26.
Page 36.
26.
No,
26.
36.
I'm sorry, 36. I'm sorry. 36. Para 15, madam. That the plaintiffs beg to submit that out of 76 households, Lordship will kindly see, 76 households of Gentleman clan, only 31 members are before this honorable court. What has happened? There are 76 households who are entitled to compensation. Now, each one of the 76 household will get his share of compensation. Now, the persons who have come before your lordship are not all representative of each of the 76 households. They are simply members. Now, what will happen? I pay compensation to someone, and tomorrow someone else comes and says, "Where is my compensation?"
Shares.
Yes. So unless these things, now my submission before lordship is, now by a regular suit, if this is decided and finally court says yes, A, B, C are entitled, I will definitely pay. Of course, they will have to bear the expenses of litigations for 10 years, lordship. And I have been given the power of attorney to represent them and all stages before the deputy commissioner for last 10 years. I have been fighting for them. Now, what they are saying there, the background scene is like this. Today, after the compensation has been determined and it is with me, they want that without deducting even 10 paisa, they want the allotment of all their shares. What will happen to the expenditures they have that I have incurred for the last 10 years in fighting for this case from one court to another? There was civil suit, there was a writ petition, there was SLP. Your lordship is aware, for last 10 years, I have fought this much. From Along, I have to come to Guwahati. From Along, I have to go to Supreme Court. All these expenses I have incurred, they want that all these expenses should go from my pocket. This is the case. Now, for this detailed analysis, for adjudication of these detailed issues, I only prayed that let there be a regular suit. I am not saying that suit itself is not maintainable. I am only saying that by a summary suit, this cannot be decided because it is not a suit based on any contract. And yes, in fact, I just wanted to show you, lordship, this impugn order. There is absolutely no discussion about order 37. At this stage, notice may go on.
This is not heard, so and so. Transfer for the. This is an application 115 of CPC against the impugn order dated 6/9/23. Passed by the land civil judge Allu, West Siam district. In connection with Miss
Case number 61 of 2023 in money suit number 38 of 2023.
38/23.
Yes.
Issue notice to the respondents. The petitioner shall take steps on service of notice to the respondents with registered date as well as the usual process returnable within 4 weeks.
4 weeks. Page 21 is my interim prayer.
21.
My lord.
MS 37, that is stay of MS 37. That is
In fact, before the trial court, we filed one application under order 7 rule 11 for
yes,
rejection of
yes,
claim.
yes. For
And
rejection of claims.
yes. Now, another application we filed on Miss Case 60 because
That is disposed of.
all disposed of.
Then why the stay is required?
No, now if no stay is given, next stage is Lordship may kindly see the impugn order. The impugn order says page 1, last page, Lordship 128.
28.
20 in the main, because of the dismissal of this in the main suit, this order is in past, page 128. Last page of my petition, madam. Last page of my petition.
198.
128.
120.
The last page of my whole petition, madam. Yes, the last sentence is
Yes.
thus plaintiff shall serve summon for judgment on prescribed form, because after I enter appearance under the CPC, the next stage is they will issue me summons for judgment, and thereafter I'll apply for leave to defend. Now the case will proceed unless the stay is given. The whole purpose of filing this order 711 will be frustrated. In fact, my lord, in course of trial, the learned trial court, my instruction from my learned friend is, learned trial court was possibly discussing, but it was not mentioned in very many words clearly, that whether in a summary suit, an order 7 rule 11, normally in a regular suit, someone files order 7 rule 11 by the defendant. But in a summary suit, whether order 7 rule 11 can be maintainable, can be applied, then there is a Supreme Court judgment, lordship. I'm just showing photocopy. This is a judgment of 2009. My lord, last page, lordship, may kindly see, is paragraph 22. Yes. Page number 9. Last page in paragraph 22.
It is required, no?
My lord.
It is also required.
Yes. It is also required to be noted that even the application submitted by the defendants to dismiss the suit under Order 37, Rule 11 of the Code of Civil Procedure were pending. But the learned trial court did not decide the same on the ground that such an application is not required to be decided before an application for leave to defend, leave to defend. It appears that there was also the learned trial court has committed an error. Application under Order 7, Rule 11 of the Code of Civil Procedure is required to be considered and dealt with at any stage of the event. The same can be decided even prior to deciding the application for leave to defend. As once it is held that the suit is required to be dismissed on the ground that same is not maintainable, there will not be any occasion thereafter to decide the application for leave to defend and or summons for judgment. Even looking to purpose for which Order 7, Rule 11 of the CPC is enacted, such application under the Order 7, Rule 11 CPC is required to be decided by the courts at the earliest. So this view of the learned trial court is also not correct, although it is not reflected in the order. But now the court says, in terms of Order 37, summons for judgment will be served on me. So unless this is state lordship, then the plaintiff will
The
proceed.
plaintiff shall serve someone for judgment.
Yes, that means the suit will proceed against me.
Decree was in favor of plaintiff.
Yes. Lordship, just Lordship, may kindly have a look at this Order 37-1, just for my education.
Please.
The Order 37-1
Oh.
of the CPC. Lordship has got, ma'am.
Yes, it's.
Order 37, Rule 3, Lordship, may kindly see first.
Okay.
Page 206 of this page. In a suit to which this order applies, that is summary suit is filed, the plaintiff shall, together with the summons under Rule 2, serve on the defendant.
1, 2, 3.
I'm reading sub-rule, Order 37, Rule 3. Procedure for the appearance of defendant, page 206.
206.
Yes, in the middle, Rule 3,
Okay.
procedure for the appearance of defendant. Yes.
This one, okay.
In a suit to which this order applies, the plaintiff shall, together with the summons under Rule 2, serve on the defendant a copy of the plaint and annexures thereto, and the defendant may, at any time within 10 days of such service, enter on an appearance either in person or by a pleader, And in either case, he shall file in the court an address for service of notices on him. Then 2 we can, subrule 2 we can skip, 3 lordship kindly see. On the day of entering appearance, notice of such appearance shall be given by the defendant to the plaintiff's pleader, or if the plaintiff sues in person, to the plaintiff himself, either by notice delivered at or sent by a prepaid letter directed to the address of the plaintiff's pleader or of the plaintiff, as the case may be. Now, subrule 4. If the defendant enters appearance, the plaintiff shall thereafter serve on the defendant a summons for judgment in form 4A in Appendix B, or such other form as may be described from time to time, returnable not less than 10 days from the date of service, supported by an affidavit verifying the same cause of action and the amount claimed, and stating that in this behalf there is no defense to the suit. So the plaintiff will serve on me a summons after he entered appearance within 10 days, a summons for judgment. Then this case will proceed thereafter. Then next is 5. Defendant may at any time within 10 days from the service of such summons for judgment, by affidavit or otherwise, disclosing such facts as may be deemed sufficient to enable him to defend, apply on such summons for leave to defend such suit, and leave to defend may be granted to him unconditionally or upon such terms as may appear to the court or judge to be just. So this way the case will proceed. Since it is a summary procedure, no question of evidence, and the court will at one stage pass the judgment. If I cannot show anything that I have right to defend, court will pass a judgment. So in the present case, where there is a necessity of determining whether this person is entitled to compensation or not, because we have to say here that some of the persons who were with the Jendu clan, other clan, so far for last 10 years, they have been fighting against the Jenpen clan. Now he has shifted 4, I can show 4 of them who have joined here as plaintiff here, and now he's again claiming compensation. He has already got his compensation.
So definitely there will be some list of beneficiaries.
Yes, beneficiary. That plaintiff is saying, we are not disputing that Jenpen clan will get. We are also not disputing that 76 households will get. But whether these persons are household, they themselves are not saying that household.
You have to identify all this.
Yes. So for identification, evidence is necessary. How much expenditure I have incurred, how much money I have paid to my lawyer for fighting this case for last 10 years for all of you. I have to adduce evidence. I have to examine my lawyer. So all these things I cannot do if it is a summary suit. It has to be a regular suit. This is my only prayer, Lordship. So at this stage, Your Lordship may kindly stay the further proceedings of the suit.
MS 38, no?
Yes.
For the question. After hearing the learned counsel for the petitioner for the proceeding of. Where it is pending?
It is pending in the court of Civil Judge Alo, page 21 I have mentioned, page 21.
For the proceeding of MS.
Number 38 of
38,
2023.
pending in the court of.
Civil Judge
Civil
Alo,
Judge,
Westian.
Westian, yeah, shall remain state. Till appearance of the.
Respondents.
Respondent.
Yes. Lordship, they make the appearance through a Vakaratama in the court, will not be able to know. Then they will say the order has gone. Till the returnable Lordship may mention, so that it is.
It is returnable.
Yes. Otherwise, we will not know when they appeared, and then they will say from that day there is no stay. Deeply obliged.
My lord, this is criminal petition also. There was effect 2 accused also in the FIR. And all this incident, in fact, the FIR was actuated by a political rivalry. In the year 2009, also, there was general election. And the accused involved in this,
Okay, 482 petition.
yes, Lordship. And the offense alleges
Where is the FIR?
FIR. Possible find FIR. Page number. Page number 70. Annexure 1.
So name of two persons have appeared in the FIR. So you have prayed for one. You're appearing for one person.
Yes, earlier Lordship, the another accused. He has also applied file application under 484. And it was allowed, and now he has been,
That is different.
yeah, yes. And
Yes, please.
this is the other accused Lordship.
My lord,
The-
this petition, I suppose, is a premature stage, man. Since it's a 482 and that can only be invoked, there is no any alternative remedy. But at this stage, my lord, since this matter has been charge sheeted matter, my lord.
Charge sheet.
So they can argue during the consideration of charges. Now, that is the stage where they can appear, my
What
lord.
for the case diary?
Scan copy.
or say, LCR.
And this is, yes, Lordship, notice. not
Summons
issued.
were issued against you. Summons were issued,
Yes, Lordship.
so you have to appear before this court.
In fact, we are appearing Lordship. Lordship has seen Lordship. There is only two accused. As for the fair Lordship, there is more than 50% involved in this incident, incident. But only this person, Lordship has seen the affair. There was a political rivalry, and this Lordship only on the basis of the statement of one gentleman.
You have to see, you have to check the case diary and the LCR, then we'll final on this thing.
Yes, yes.
Matters.
Now, for
House answer, yes, please.
D come to.
House answer. Learned counsel for the petitioner, learned Presbyterian is appearing for the state. This is an application under section 482 CRPC. Praying the enforcement of the proceeding of cheer case. Number 46/2009. In bracket. Corresponding to Teju PS case number 46/2009. Under section 3411149 and PC. Issue notice to the respondent to. The petitioner shall take steps on service of notice to the respondent to the registered entity as well as usual process returnable within 4 weeks. Call for the scan copy, no?
Scan copy of
of the
LCR.
LCR as well as case diary. Case diary, list the matter after 4 weeks.
Lordship, till then,
Yes,
the proceeding before the court will may be stayed. Much obliged.
yes, password for the day,
No, thank you.
timing. Oh, and number 16. We'll hearing.
This matter was actually part heard yesterday, I think,
No, yesterday.
council, bail application.
So what to do? Nobody is present here.
Counsel for the petition is not present, my lord.
I think he's from Guwahati.
Guwahati.
And
Since
whether he's-
this matter is fixed today, I suppose he is around here, my lord, but maybe he's not. Pass over for a time.
Yes, yes. No, please. No, please. For the applicant on call. Just the matter after 2 weeks. Page?
To the appellant, my lord, for consideration amount of the sale deed of the land dated 1911-2009, my lord. And second is, my lord, whether a judgment and decree can be passed by conferring title, right, title, interest, and ownership over the land in question on the strength of the sale deed, which is not duly registered as per law. And third, my lord, whether magistrate can register a sale deed of the land which is not located in their jurisdiction. So, my what happened, my lord? Well, what happened? And there was a title suit, my lord. And here I am the, my lord, in a trial court, I'm dependent, my lord. And past appellate court also, I'm dependent, my lord. And my lord, trial court partly allowed, my lord. And here, my lord, responded plaintiff, claimed that title of the plot of land, my lord, on the strength of the one gift deed purported to be a sale deed, my lord. I'll take my lord to the that part, my lord. May I take my lord to the phase 90, my lord, 90, my lord. My lord, it's a
If deed.
gift deed, my lord. And on strength of this, my lord, they filed title suit. And the defendant objected this gift deed is void ab initio because in content they have given the consideration amounts, my lord.
Give with consideration.
Yes, my lord. So
So
depend,
give always without consideration.
yes, gift deed should be always without consideration. So our objection to this exhibit
was that this gift deed is void ab initio because there is a consideration amounts. Then what the finding of the learned trial court was that though content it's written a gift deed, but intent was to enter into a sale deed, my lord. And content of this gift deed is a sale deed. Though on the basis of that, my lord, learned trial court partly allowed, my lord. Partly allowed means, my lord, some of the amounts has already paid to the dependent, my lord. So the learned trial court, by their judgment decree, my lord, partly allowed, directed the dependent to repay the part consideration amount, my lord. That is amount to 2,50,000, my lord. On agree by that order, my lord, the plaintiff herein, my lord, opposite party approached the past appellate court, my lord. And past appellate court reversed the judgment and order of my lord trial court, my lord. Reverse the judgment and decree of the trial court, my lord, that the consideration amounts was paid to the dependent on 3 occasions, my lord. And this gift deed is not gift, this gift deed as sale deed, my lord. And it is duly registered. Finding of the past appellate court was that it is duly registered. And this is a sale deed.
Okay, not a gift deed.
Not a sale deed. Yes. Then another finding is that, my lord, that consideration amounts was paid to the defendant on 3 occasions, my lord, which is not a part of pleading, my lord. So judgment, my lord, I'll take my lord.
So issue notice in this, notice
No.
was issued earlier.
No, earlier issued, my lord, because formulation of substantial questions of law, the notice others.
The other side, it will be better.
Well, as per section 100, my lord, the substantial question is to be formulated, then notice is to be go, my lord. Earlier, past question notice was issued, my lord. My lord, may kindly see order 31st July, my lord. As per section 100.
Yes.
Yes,
Can be formulated,
yes, ma'am.
substantial question should be formulated
Yes, ma'am.
at the time of admission.
Yes.
But after hearing both sides, the substantial question will be formulated, that will be better. In that case. But notice has not been address insufficient, report is there,
Yes, madam.
address insufficient, notice has not been served to the other parties.
Address as per their own address in the trial court. I have given the address, my lord. My lord, this is the substantial question may be formulated, my lord. Then on the substantial questions, the
Substantial question after hearing both sides, that is required.
as per my lord, section 100, as per my knowledge, my lord, substantial question is to be formulated past, my lord. Section as per section 100. my lord.
That is not required, it is required at the time of admission, but it is not admitted today because the other side not admitted. After hearing the other side. it is
31st, my lord, order of this court, my lord, order of this court on
formulate substantial
31st.
question. Yes, yes, please.
Order of this court, my lord, on 31st July, the substantial question is to be framed past, my lord, on the order of this court, my lord, 31st July, my lord.
31st July,
Yes, ma'am.
31/7, yes. Notice on the soul, it is in the sense of the notice by the school, the notice was already issued. Yes, notice was issued, no problem.
Yes,
Service is still awaited.
Yes.
So in the meantime, there will be hearing on the substantial question of law. So other side, it will be better to hear both sides and then to formulate the substantial question. At the time of admission, really.
my lord, otherwise my understanding is past substantial question is to be formulated as per section 100.
Then
Then
you
on,
have to admit the petition.
on that question, substantial,
On their question at the time of admission. At the time of admission of this appeal.
at the time of hearing, my lord, at the time of hearing on the substantial question of law, the opposite party is to be invited, my lord, to argue on the substantial question of law, my lord, as per section 100, my lord. Close 5 matter.
Yes, at the time of hearing,
Yes.
the. Still awaiting hearing.
So my humble prayer is, my lord, that I have given the substantial question, 3 point substantial question of law. This may be formulated and opposite party, if need be, I will take a press step, my lord.
There is no cell deed, it is not a cell deed, what you have stated,
My
this
lord,
is not a cell deed,
my lord,
what you have stated, that is not registered, I think. You have stated so, this is not a cell deed.
yes, yes, my lord. I challenge this one as did that instrument as not a gift deed, and moreover, it was not registered as per the registration act, my lord.
Where is the deed? Yes.
Page 90, my lord, this is the
Page
instrument.
90, yes,
Yes.
it's a gift deed.
Yes, give this, well, content, reading the content. It seems it is intended to be a sale deed, my lord. They have intended to make a sale deed, my lord. Therefore, finding of the trial court was that it is not a gift deed, it is sale deed, but consideration amount was not fair, fully not fair. Therefore, partly allowed,
The
the
other side received the amount,
others not received, my lord.
then how it is a cell deed?
Therefore, I'm the, my lord, dependent. So they are finding
Where is the judgment?
judgment, yes, my lord. My past trial court judgment, my lord. Yes, my lord. Trial court judgment is at face, my lord.
Page?
Page, my lord, 112, my lord. 112, my lord.
112.
Yes. The finding, my lord, finding is
Civil judge, civil judge,
yes,
senior division.
senior division, UPR, my lord. And against this judgment,
And
the respondent here in respondent who was plaintiff in district has appealed before the district court, my lord. And district court reversed this judgment, my lord. And holding that gift deed is a sale deed and consideration amounts was fully fair on 3 occasions, my lord, which was not part of pleading, my lord.
LC received.
No, my lord, LC also not called for, my lord. So, my lord, if my lord wish to peruse the LCR may be called, and on perusing the LCR, the question of law may
That
permanent
is also required, no?
requirement,
Itself.
my lord. And impugned judgment is my challenging is at phase, my lord. Phase 19 is the judgment and decree of the past appellate court, ma'am.
Page
19, ma'am.
19.
Yes, ma'am. Is a decree and judgments of the first appellate court, ma'am. And my lord will find the findings at phase 30, ma'am, 30, madam.
30.
30, madam. Paragraph 25, madam. In view of the legal position and fact, the present in the case, it is held that the paper exhibit is the sale deed registered on so and so, having witnessed by 4 witnesses. Finding of the past appellate court is that, my lord, it was registered in the court of judicial magistrate past class, actually, which is located out of the jurisdictions, my lord, which is not the disputed land, my lord, question is not within the jurisdiction of that, my lord, magistrate, my lord.
It cannot be treated as sale deed also.
Yes. On the basis of that sale deed, my lord, title cannot be confirmed, my lord, because which is not duly registered, my lord. On the basis of that sale deed, the past appellate court has compared the right and title over the, my lord, plot of land, my lord. And moreover, the considered amounts which is said to be fair was not the part of pleadings, my lord. When this amount was paid, when that amount was paid was not part of the pleadings, my lord. So which is not part of pleadings cannot be recorded on finding, my lord.
Whether it is a board of admission or not, that is the question. So others should be present.
So this is the, my lord, then, my lord, LCR may be called for me.
No, perhaps, okay, we should take steps, second respondent. Full respondent, is that?
Sole respondent.
And Mr. Swansea, counsel for the petition, appealant. Notice has not been properly served to the. Not been served to the respondent. With the postal ring of tax, address insufficient. So better to take steps to, Dusty,
My lord, Dusty may be not possible. Alternative, my lord, by publishing.
substituted manner
Yes, my lord. So,
to paper publication.
yes, ma'am.
Dusty, why not possible?
Because they won't take my lord.
Maybe.
So okay, then, my lord, Dusty, then
Professional
I'll try Dusty, my lord. Try Dusty.
Learned counsel for the petitioner, so that's that. Would like to take steps, against the respondent to just the mode of service. Prayer of the petitioner is an appellant, so not petitioner, appellant is allowed. The appellant is. Shall take steps. The respondent to just the mode of service and after. Service. An affidavit. You should file an affidavit, no? After service.
Yes, yes.
File an affidavit to that effect. Give the date, please, 1 month, check.
After 3 weeks,
3 weeks,
after 3 weeks.
4/10. 4/10,
My lord, IA is also there, ma'am.
yes,
IA is also there, ma'am.
I have to evidence of the,
No problem. My lord,
I for what?
IA will stay of the.
Only stay.
My lord, that's, my lord, then LCR may be required.
Yes, LCR definitely report.
Yes,
For the LCR, yes, call for the LCR.
Publish.
My lord, may I please? My lord, last occasion, CDY called for. So if CD is available, then
Did you receive?
CD, your lordship, we have not received yet, your lordship. Actually, your lordship, the concern IO has made an accident because of that she is bedridden. So because of that, perhaps she could not be able to produce or furnish the CD today. So it matter may be fixed after your lordship, after a week, your lordship. So that enable us to produce the case.
482 matter.
Yeah, it's a for quashing, your lordship.
Wash. If he submits that, CD is not available as the I met with an accident and raised for 1 week or 2 weeks.
2 weeks, your lordship.
It's for 2 weeks times to produce the case diary. Charge sheet has not been submitted.
Not yet, your lordship. Investigation is progressing, your lordship. Deeply obliged. Obliged.
After 2 weeks. 12.
Please, my
Yes.
in this case, my lord,
It's a leave application.
leave application. That
Appeal against acquittal.
respondent acquitted in check bounce case.
Take bounce.
So therefore, this leave application we have filed under
So others have not appealed. Till
other
now.
side, we have taken so many steps. Kindly, your lordship may peruse the order dated 9/6/2022, service completed,
9/6.
9/6/2022. Therefore, matter was posted for hearing. But then, my lord, your lordship may office notice of 4/6/2022 and order dated 9/6/2022, service completed,
You have sole respondent.
sole respondent. So your lordship at this stage, may I pray, since
Whether
despite
he has received the
re-
notice.
received the
that is
notice, therefore, in the office note also,
everything, Criminal leave application to disposed of.
at least today, this leave application should be disposed of, your lordship. And then in the main appeal petition, LCR has to be called for. Since the opposite party, your lordship, despite of
Any signature from the other side?
no, that was kindly office note 4/6/2022 may be perused, your lordship.
4/6 a copy of.
4/4/6/2022.
Copies of notice responded. on-
Service notice harassment through CGM SEPA. Through CGM SEPA, your lordship.
They have appealed? Not appealed.
Not appear.
So this is received from the London CGM SEPA, same is placed with record. Record flagged. This is. This is the notice. Okay. His name is Ramin Young.
Young, your lordship. So therefore, lordship, today, my humble submission, humble prayer.
This.
This leave petition may be disposed of and LCR may be called for main appeal and matter may be posted for hearing after 3 weeks.
Understood. Well, I'm sorry. This is an application. London Council for the petitioner, none appears further. Respondent. This is an application filed under section 374 in bracket 4. CRPC to grant a special leave to file an appeal against the judgment and order dated 7/8/19 passed by the learned CGM EPR in CR case number 38/2016, whereby the respondent was acquitted from the offense acquitted from the offense and punishable under section 138 of NI Act. Counsel for the petitioner submits that. What are the grounds you have taken in the petition?
Despite of clear and cogent evidences, the learned trial court below erroneously acquitted the respondent because check.
Yes,
Huh.
he put his signature on the check. What
Huh.
is there? That is not denied.
That is not denied. Even he issued the check, that is not denied. But despite of all those things, your lordship,
You have
erroneously
stated in your petition,
in my petition as well as in my leave petition also.
in the leave petition, that the grounds of appeal has been stated in the leave petition. It is also specifically supplied with that. It is not denied by the respondent that. And his signature in the check, which he has said to the petition complainant in CR case number 3816. As per office note, next paragraph. As per office note, dated 4/6. 22 or 23? 22,
Lordship,
4/6/22.
2022 lordship.
1 year from. 4/6/22. Notice has been. 4/6/22. It reveals that notice has been served to the respondent, not one, only, you have only one respondent, no?
Only one respondent.
Receipt from CGM SEPA. It transfers that notice has been properly served to the respondent, in spite of that, who did not appear before the court to contest the matter. Hence, the leave application is allowed. Case is registered, case has been registered. It has been registered, no? Okay. As the case has been registered, less the matter for admission.
Lordship. And then meantime LCR in respect CR case number
On the
30.
date of admission, on the date of admission, they can submit that. Issue notice. to-
Lordship.
After 1 week,
After 2 weeks, Lordship.
after 2 weeks.
Highly obliged.
I that's disposed of. no?
Highly obliged.
Your may lordship, lordship is still lordships, my senior is still, matter is going on lordships in court number 1 lordship. So lordship, if possible, lordship, after some time or at 2 lordship, if possible.
Lordship, here lordship, expo number 2 also need to be present, lordship.
Lordship, here is the case, lordship, Bakalan, lordship, service is completed, lordship.
Service is complete.
Yes, lordship, service is completed, lordships. And order is passed by the executive magistrate, lordship.
Security base.
Yes, lordship. Yeah.
The notice has been served to the respondent. Respondent 2. One is the additional PP, no? I mean, state. Survey respondent not yet received. Service report in respect to respondent to receive and from receive.
Stage already there, Lordship.
Lordship, my senior is coming also. Senior is coming. Well, I'm extremely sorry, occupied in the code number 1.
You're a busy man. Busy lawyer.
145 for Lordship. 145, isn't it? I don't know.
So respondent number 2 notice has not been served.
Lordship, sir,
Where is the order of this note? I didn't find it.
Lordship, here is an office note, Lordship, here is an office note, Lordship.
Overlap number. Not a file on table of respondent. Okay. Service
Okay, okay,
report
okay,
in
ma'am.
respect to respondent to receive,
Yes.
receive.
User force, what?
Yes.
Hmm.
Till date.
It is the year order.
Sixteen point.
1 point. Open order, hmm? Okay.
Respondent,
Millard.
what's the name of respondent do? Some notices has been served, what is name?
Yes, Millard.
Respondent is
Rico River.
Rico Riva.
Millard, may I assist to finding out
Yes,
that
yes.
order? Just. Yeah, ma'am. Yes, ma'am. 20, serial number 28, 16/5/2023, service upon, service, in respect of respondent number 2 already received from OC Police Station, Bassett. Kindly refer to serial number 27, office notes it.
The
Or
whether the
activity-
notice has been received by that person,
Hmm,
that is required.
yes, serial number
You see-
27. I will just, I refer to this. Service report in respect of respondent number 2 received from OC Police Bassett, and the service is kept with the records like, it appears services. See the back section.
Whether he put his signature, where is it? I'm returning. Rico Riva. Received. Received. Rico Riva. no? This is,
There is no number.
okay. Rigo Riva. no?
Yes. Yes,
145 matter.
yes, madam. Now,
So what to do?
order is not sustainable because the melody is kindly aware whether we or the
In
legislature,
145, there is no question of title. Only the possession.
only the possessions cannot.
So what to,
This order is bad. The Kawa were in my favor. And in the meantime, the learned additional deputy commissioner, without affording a hearing of, without affording the opportunity of being heard, has passed this into an order. My lord will kindly take up this 145 for a moment. Procedure where dispute concerning land.
Yes, 145.
Yes. Procedure where dispute concerning land or water is likely to cause breach of peace. One. Whenever an executive magistrate is satisfied from a report of police officer or upon other information that a dispute likely to cause a breach of peace exists concerning any land or water or boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in which dispute to attend his court in person or by pleader or a specified date, and to put in written statement of the respective claim as the fact of actual possession of the subject of dispute. For the purpose of this section, as per land water includes below, a copy of order shall be served in the matter provided for so in summons and all. No summon was given. The magistrate shall then, without reference to the merit or claim or any parties to right process, subject of dispute, peruse the statement so put in, here the parties involved. And with 4 also,
Prior to passing of the order, no summons was issued to you.
nothing, this was not followed. My lord, in case of this, the power of magistrate, have you given this judgment? No, yeah, important. My lord, for brevity, my lord, this is a judgment by Justice Ansari, long back, my lord.
Oh, it is here in the.
There are 6, 8, and 11, my lord. It's very important. 6. My lord, before that, my lord, may I indulge with the impugn order so that my lord becomes more clear on this. Hold on for this judgment for a moment. Kindly come. Page 17.
Page
Yes, 16.
16
16, 1 6.
of your
17.
petition.
17, no, no. Page 17. my lord. Annexure 2. It will take only 3 minutes. my lord.
Plan.
My lord, shall we proceed?
Yes, yes.
Yeah.
5, 6, 20.
Yeah. A petition was received from Erico Riba, son of so and so. The Camp Dari Leparara district, Arunachal Pradesh, petitioner to the effect that his possession of ancestral land at so and so. Leparara district, Arunachal. In view of these obstructions created by respondent over the peaceful possession of the land, there is likelihood of peace being breached. From the preliminary inquiry and other sources, it appears that there is apprehension of so serious breach of the peace arising out of the said land dispute. Accordingly, OCPS Basar was directed to inquire into the matter and submit report as to existence of apprehension of breach of the peace. On 28 May 2020, the report was submitted by the OCPS Basar, indicating that there is every possibility of peace being breached at any moment and resulted for invoking section 145 CRPC to maintain peace and order. The case history in brief is that this is land that the disputed land is claiming by both petitioner and the respondent. Land dispute matter was pending for long for the purpose of arriving at final solution and also to contain serious breach of peace. An order was passed to Village Council of Dari Village, Bango Level Kaba by Additional Deputy Commissioner to settle the land dispute case in accordance with established customary laws. Accordingly, summons were issued to both the parties to appear before Village Council on so and so date for amicable settlement. However, this order issued of the additional Deputy Commissioner Laparada District Basar was stayed by Honorable High Court, Itanagar so and so, so and so, so dated. Delayed 22/11/2009 since then, case is pending, hence the present case. Now next is, seen the police report, other available records in hand, also examined. I am satisfied from the police report submitted on 28/5/2020 and other reliable sources that a dispute is likely to cause a breach of peace exists concerning ownership and possession of the disputed land. All the materials, evidences placed before me has been perused and examined meticulously. He writes meticulously, what meticulously? From the careful examination of police report and other available records in hand and other information, it clearly appears that there is possibility of confrontation between the parties. At last paragraph of the report reads, undoubtedly there is apprehension of possible confrontations in which, in such situation, magistrate is left with no alternative than to prevent breach of peace and pass order under subsection so and so. In such situation, while resorting to the summary provisions laid down in section 145 CRPC, magistrate does not inquire into the merit of claims of the parties, even their right to possess the subject of the dispute. Magistrate is only concerned with the question as to who in actual possession on the relevant date. The possession of the petitioner is neither disputed nor contested. Permanent dwelling house of Sri Dapni Riva, hear me, father of the petitioner, has been in existence since many years, which has never been disturbed at any point of time. It is
So
also.
that is the father of the petitioner, the present petitioner. Okay.
It is also reported that construction materials collected for construction of new houses exposed to sun and rain and left to decay, which has caused irreparable loss to the possessors. Therefore, I am satisfied. Now, that means, let us pause for a moment. Now, what is the requirement? Once there is a police report, you ought to comply with 145, the mandate of the 145. You have not done this, just you have jumped it. So kindly see this, that's why this order is bad. Therefore, I am satisfied from police report and other reliable information that there is an indication of a breach of the peace.
Yes.
For the purpose of preventing serious breach of the peace, following orders are passed for immediate compliance. This is important. One, Sri Rico Riba petitioner has been in possession of the land all along. The object behind the provision of section 145 is merely to prevent the breach of the peace by maintaining one party to the dispute in the possession and forbidding the other on pain of penalty to interfere with. Therefore, Riba shall continue to possess the land till matter is decided by the civil court. Now, you cannot decide a title. You cannot. And there is a Kava order already in my favor. Peace will be breached if
Any
other.
civil case is pending between the parties.
Kava decision.
Parties.
Kava is already in my favor. Kava decision. It's a 50-50 line.
Still pending.
No. Decided.
Already disposed of.
50-50.
50-50.
50-50, but I have executed the construction work in my portion of the land. But somehow the mana of the god fell down through the
No, by the civil court or on your
village
decision or
village authorities.
village.
Village authority. It is annexed. I also this. Therefore, so and so continue to possess the land till matter is decided by the civil court. Peace will be breached if other parties may enter into plot where permanent dwelling houses or is constructed and inter-family's house. There will be no interference from the other party. Any violation of this order shall be treated seriously and necessary proceedings shall be drawn against any defaulter in accordance with law. Another minute, the question is, while passing this, the learned additional deputy commissioner has not applied the mind, nor has appreciated the objective and mandate of the section 145 of the CRPC, which the legislature has intended to incorporate this section in the statute. Melody will come to that cover the Euro. Melody, for the moment, kindly come to 12. Page 1 to
Page 1, 2 of your petition.
12. This, my lord will become more clear from this. My lord, this is handwritten one. The type copy is at page 14, my lord.
Okay.
Yes. On this date, 28/9/2019, a disputed land came between Tope River and Sri Damrik River is held by adopting Ciodari order under chairmanship of so and so, along with Kava judge. Say that as per the witness and submission of the documentation by Sri Tope River and Damrik River, disputed lands would be divided as equally 50-50. According to the document produced by Sri Tope River, that Rikki field is belong to late Mogum River, and also Sri Tope River has a right to claim the said land. Nevertheless, Damrik River is genetic father of Tope River. As such, the land has divided into equal part 50-50. Hence, the Kaba has observed that the Magum River was transferred his land coded to Sri Tope River. Therefore, Kaba said Sri Tope River has 100% right.
100% right.
100% right. But Manoj, the Kaba decision,
Kaba decision.
Kaba
That is
decision has
50-50.
settled 50-50.
Subsequently, then what's to?
In the meanwhile, what had happened? This landed additional deputy commissioner was on the verge of transfer. Manoj. He passed that impugn order. Okay, see. Now, Manoj, then what happened subsequently at page 16, Manoj?
Page 16.
Yeah. Now, what happens is, this was and set aside this in continuation of earlier letter number that is so and so, a Bango level Kaba, which was fixed on 15 of so and so, with the land dispute case in between so and so is hereby refixed on 25th of November to 2019 at Bango Dare at 19 hours positively. Therefore, for the parties to the case is hereby directed to bring their witnesses, if any, in continuation with so and so a reported Kava authority. There's a Tope River respondent is avoiding to turn up before the so and so. Now, Milord, what had happened? How this, Milord, let me explain how this case was stayed by this honorable court. My lord is aware.
Tope River means in favor of you.
Yeah.
Kaba decision
Yeah.
means in favor
Yeah,
of you.
my lord, just I'm posing and trying to assist my lord. Why this Kaba decision? Why this order at page 19?
Page 9.
Page 16, page 16,
Page
page 16 was stayed by the honorable court. My lord is aware that 2013, my lord, for GLT page 1109, paragraph 32, 15, 16, 30 to 30 and 32.
That I don't know.
No, Registrar General. I'm
Okay.
Registrar General Guwahati High Court versus Union of India. So there, dealing with that separation of a judiciary from executive is a must. So then the judgment came. So now thereupon the executive will were these empowered to direct the village authority to held the Kava. So that is on the premises. Letter decision by B.K. Sharma is Navum Nikum versus State of AP in the 2015 judgment. Milord. There, what had happened, the forum was created as an appellate for the executive. Milord. So now, because of that judgment, now Arunachal, Milord, that's Arunachal Pradesh Civil Code Act has come.
Act is,
Yes. So now, Milord, that Kava village authority is known as the lowest customary court. Milord. Now the interference of executive is no more. So that is the reason why this was sustained. So Manoj, you kindly appreciate that the judgment by his lordship answering that I'll rely one more. Is good. 2007 for GLT.
Yes, 2004, 7 for GL. Yes,
No, this 8 is important. The interpretation 6, paragraph 6 is read about all those descriptions. Para 8. the provisions contained in subsection 1 of section 145 so that the source of information for the purpose of drawing a proceeding under subsection 1 of section 45 is not material. What is material is that executive magistrate must be satisfied about existence of a dispute as envisaged in section 145(1) and must assign the ground of his being so satisfied. These apart, dispute must relate to land, water or boundary therefore, and dispute must be such which is likely to cause breach of peace. The expression breach of peace does not really mean mental peace of the parties concerned. Disturbance of public order is distinct from the actions of the individuals which do not disturb the society to the extent of vibrating a general disturbance of the even tempo of the life of community in a given locality. When a party illegally or forcibly occupies land of another people in general or neighbors of such a party may be shocked and mentally disturbed, but the life of community may still move, keeping peace with the tempo of the life of the community. If by such an act of dispossession, even tempo of the life of the community is disturbed or jeopardized, it may become a case of disturbance of public order and tranquility. The acts of private party which affect personal right of another do not disturb the tempo of the society. For such feuds are private feuds. Basic of jurisdiction under section 145 is a dispute which is likely to cause a breach of peace. It is not a breach of mental peace of the parties to apprehend danger, breach of peace in the locality. Now, just for a moment, I am posing. Kawa decision, my lord has seen 50-50. Where is the question of public peace and tranquility being breached? This principle hits into law. Ordinarily, a person dispossessed from his land shall sue for recovery of immovable property under the provisions of the Specific Relief Act. And if there is a threat of his dispossession, he should institute a suit to obtain injunctions. There are ordinarily forum for establishing rights of the litigants. A proceeding under section 145 is therefore an extraordinary provision to grant extraordinary relief when there is likelihood of breach of peace in a given locality. Well, and again, I am posing there is absolutely no breach. The final order of the magistrate is subject to the decision of the civil court. Here, Milord has seen the impugn order. The possession was given to him. He do not have the power under 145 proceedings. It is therefore clear that private dispute between two parties, which does not disturb law and order or occasion breach of peace in locality, the forum of getting relief is the civil court of competent jurisdiction and not an executive magistrate. In Ram Sumer Puri Mahant versus State of UP, reported in so and so, the apex court has discouraged drawing of proceedings under section 145 as far as possible. In fact, Ram Sumer Puri Mahant Supra lays down that a magistrate should initiate a proceeding under section 145 only when the essential elements of the provisions contained in the section 145 are found to be present in a given case. Number 9, Milord, that you need to read. 11, Milord, is coupled with the above, the dispute in present case as indicated is out a private dispute, Milord. In as much as the dispute did not involve any other than the parties to the proceedings and the member of the general public were neither affected nor were they shown to be interested in the dispute. Consider thus the learned magistrate had no jurisdiction in the matter and could not have drawn a proceeding under section 145. This aspect of the matter appears to have totally escaped the notice of the learned revisional court. Well, these order must go, Milord. Then another, I need not to bother my lord much, that 2015 GLT 442 I will supply to you if you require this. My lord will only see this para 4 is important. Notice to be issued to parties. Second page, my lord. That's
Yeah.
para 4. Upon receipt of said application, the learned magistrate had drawn up a proceeding under section 145 or 6. The apprehended breach of peace in the area where the disputed land was situated, and accordingly he issued notice on second party petitioners. Here they have not complied with. This is one. Well, that's para 15 is most important in this judgment. This distinction has been made on the public law, public order, law and order of, or public tranquility is. But this is this paragraph, my lord, will refer to. My lord, still, that third, the para 15, my lord, next page, my lord, on the top, my lord. Third line, my lord, please stop. Please stop.
Para number,
Para 15 only, next
15.
page, para 15, next page, my lord.
next page.
Yeah, there is a third line from the top.
Yes.
Now line 3. Right, my lord.
Yes.
Fine. Huh. Now that I find all around is that just on some pretext or pretense flood of proceedings under section 145 CRPC are entering the courts like flood water, entailing the wastage of public money and public time before taking up a proceeding under section 145 of the code of the magistrate code. The magistrate must be careful, cautious, circumspect, and slow. The quintessence of the decision of the Supreme Court in Ram Sumeri Puri, that's which we have referred to now. Mahant versus State of UPAR so is to discourage proceeding under section 145 of the code as far as possible. It is necessary to avoid multiplicity of litigation, which is against the interest of the parties. And in most of the cases, public time is wasted over meaningless unnecessary proceedings. In Ram Sumeri Supra, a note of warning has been sounded by the Supreme Court that the magistrates will initiate proceedings under section 145 of the code when the essential elements of the sections are found to be present in the case. However, these are my passing observations. So that, well, kindly see, no mind was applied. I was going through one judgment on a tender. There is one beautiful passage on that. It says, just by Justice Gawai, that Madras Aluminum Construction Limited, very recently, just few days back. So they said, action of the state respondent, even in the realm of contract, must be in consonance with the mandate of Article 14. Here, my lord, this has been done away with. So, my lord, just rest. I'll need to refer, my lord. These are all there, my lord. This rest, my lord, will only refer to that. This thing also 20, my lord, I will indicate a paragraph. Paragraph 20, my lord, 21, 22, and 23. My lord.
This judgment,
Yeah, in the of the judgment.
20,
My lord, 20, 21, 22, and 23. Apart from 4 and 15, my lord. That's good. And my lord, for brevity, my lord, let's kindly come to my grounds. My lord will have to pick up few points from here while delivering the judgment.
in your petition.
Yes, page 6. I'll only indicate 2-3 paragraphs. C, ground C, page 6, ground C.
Page
6.
6.
Hmm.
6. yes.
Yeah, C, my lord, will come. This
C.
normally A and B, my lord, that normal legal literature. For that, the learned ADC cum executive magistrate, La Parada district, Basar has manifestly committed erred in law while passing the aforesaid impian order, which does not reveal apprehension of breach of public peace and tranquility arising out of dispute between the parties over the possession of the disputed land. And as such, being a private dispute, it is civil in nature, which is beyond the scope and ambit of jurisdiction of the executive magistrate provided under section 145. The first ground to assail, my lord. that D is also that civil may not, D is also important, then one more paragraph will come. It is submitted that the learned executive magistrate Basar has failed to appreciate that the dispute between the party is a civil nature. If a person disposes from his land shall sue for recovery of immovable property under the provisions of the Specific Relief Act, and if there is a threat of dispossession, every party can institute a suit to obtain injunction. That's Order 39, Rule 1. Therefore, the said impure order is bad in law and same is liable to be. So, Malad, that Malad, for the learned executive magistrate has failed to appreciate that the dispute between the private party and private respondent and the petitioner is a private dispute which remedy available is in civil court, whereas in instant case, Kaba already decided the title over the disputed land in question, and Kaba is a competent court and has a jurisdiction to decide the title ownership of land as per 1945. The said Kaba decision, still is in force. That Kaba decision 28/9/2019 is still in force. That F may be recorded, just F may just be recorded. Will not refer too much. My lord will just kindly calm down to para 8. It is a repetition, yeah.
Para 8.
Para 8. Page 8, my lord. G. Sorry. My lord, there is a small mistake in page 8, my lord. After G, H, it should be H, my lord. I have written D, my lord. I apologize for the mistake, my lord. Page 8, my lord.
Page 8.
Kindly read it as H. H for Honda.
GH.
G, A, B, C, D, E, F, G, H. And next is E should be read as I, my lord. You know, this is important. This ground is very important for me because it is submitted that the additional deputy commissioner Basar, Leparda district has misconstrued the provisions of law, specifically subsection 1 of section 145 of the Code of Criminal Procedure 1973, while passing the impugn order dated so and so, without requiring the parties' consent to the dispute to attend his court, or by a pleader without specifying date and place, and to put in written statements of claim and counterclaims of the parties relating the land in dispute. Therefore, same is liable to be quasi and set aside. The last leave of my submission is this, because it is submitted that the additional deputy commissioner Basar Leparda district has failed to appreciate the object of section 145 of the code, which is to prevent breach of peace, and for that and to provide a speedy remedy by bringing the parties before the court and ascertaining which of them is in actual possession, and to maintain a status quo until their rights are determined by a competent civil court. Niceties of titles are not to be gone into. Therefore, the order dated so. Therefore, my lord, the prayer is advanced kindly was set aside because the properties, they are in possession of the board 50-50. Where is the requirement? There is no breach of public peace and tranquility. If
Litigation between the two private parties.
Lordship, I am not going to the effect of the case, Lordship. I am into the 145 CRPC, which is invoked here, Lordship. Lordship, can I, Lordship, take a Lordship in the 145 CRPC once again, Lordship? Lordship, 145 CRPC section. Lordship, Lordship may go to the 145 clause 6A, Lordship.
6.
Yes, Lordship.
6A. Yes.
Lordship. Lordship, may I read, Lordship?
Yes.
If the magistrate decides that one of the parties was or should under the proviso to subsection 4, I will go later state as subsection 4 also, be treated as being in such position of the said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law. and forbidding all disturbance of such possession until such eviction, and when he proceed under the proviso of subsection 4, may restore to possession the party forcibly and wrongfully dispossessed. And B also lordship, the order may under subsection shall be served and published in the manner laid down in subsection 3. Now lordship will go to subsection 3 and 4 as well.
3 and 4.
Lordship. Subsection 3 is lordship is hereby a copy of the order shall be served in the manner provided by this court for the service of a summon upon such person or persons as the magistrate may direct, and at least one copy shall be published by being affixed to some conspicuous order or placed at or near the subject of dispute. And lordship, subsection 4 states that the register shall then, without reference to the merits or the claims of any of the parties to a right to possess the subject of dispute, peruse the statements so put in here, the parties receive all such evidence as may be produced by them, take such further evidence, if any, as he thinks necessary, and if possible, decide whether any and which of the parties was at the date of the order made by him under subsection 1 in possession of the subject of dispute. Lordship, here, lordship, this magistrate have applied subsection 4, but lordship, it can be read with subsection 6A as well, lordship. So lordship, this is order, lordship, it's not regarding the title, lordship, they are repossession, lordship. And lordship, this order has been passed after receiving lordship report from the lordship, OC lordship.
They did not receive the notice before passing the order.
Lordship, this is
The order has been first expired.
lordship, this order can be lordship served as a lordship summon, lordship. Because this order, lordship, here lordship subsection 6A, lordship, is clearly indicate that he shall issue an order declaring such party to be entitled to possession thereof. And it read with section 4, lordship, 3 as well, section 4 also. Subsection this one, clause 3 and clause 4 also. Well, lordship, subsection 6A, lordship, subsection 6, the
applies
clause
in case
B,
of disposition.
lordship.
6 applies in case of disposition.
Lordship, here, lordship, this matter, lordship, regarding the party that this disputed, lordship, this land, lordship. Here, lordship, their Keva, lordship, already, lordship, Keva is lordship called for, but lordship, here in their petition also, the petitioner, he declined to attend the lordship in the lordship page 16. Lordship, here this order, lordship, where
Page 16.
lordship. It is also reported the Keva authority dated Tope Riva, which is the lordship petitioner in this petition, avoiding to turn up before Keva hearing fixed on this one, lordship. The lordship, here, lordship, it indicates that lordship, maybe lordship, there are some disputed lordship between this party. They are not in the terms of lordship, like some kind of like settlement, lordship. And after that, lordship, maybe there is apprehension of some lordship, public lordship tension, like
Private
is arising.
dispute between the land,
Lordship.
between the private parties.
Lordship, and this order is not regarding the title, lordship, it's only possession. Regarding the after going to all the situation where the lordship on in the order is reflected with this line para 3, lordship. Third para, lordship, on 28 May 2020, the report was submitted by the OCPS Basa indicating that there is every possibility of peace being breached at any moment and requested for invoke under section 145 CRP to maintain peace and order.
Where is the order?
Lordship, this is lordship, page 17, lordship.
17.
Lordship, it in the order here is
That is
reflected,
the
lordship.
OC, order of the OC.
Let us order after this report submitted by the OC,
Where
lordship,
is the
this
report? Report
Lordship.
you don't have.
lordship, I have only this one. It's maybe this there in LCR, lordship,
LCR.
lordship. And lordship, this lordship, in 145 lordship, subsection 10 also indicated nothing in this section shall be deemed to be in derogation of the power of the legislature to proceed under section 107. And lordship will,
Finding
145, 145, 10.
yes, lordship. Subclause 10 is it states that nothing is in this section, means 145, shall be deemed to be in derogation of powers of the magistrate to proceed under subsection 10 or 107. What is 107? 107 is security for keeping the peace in other cases. When an executive magistrate receives information that any person is likely to commit a breach of the peace or disturb the public tranquility or to do any wrongful act that may probably occasion a breach of peace or disturb the public tranquility, and is of the opinion that there is sufficient ground for proceeding, he may in the manner thereafter provided recursive process to show cause why he should not be ordered executed. Lordship, here the show cause is not necessary, Lordship. If this 145 is, Lordship, invoked, where the breach of, Lordship, peace and public tranquility is likely to be held, Lordship. Lordship rightly pointed out that this order is not regarding the title, Lordship. It's not declaring the title of the particular land, Lordship. It's only the possession regarding, wherein the both the parties have some disputed, Lordship. If seeing this, every apprehension of there being any possibility of being peace being increased by any moment or requested, there after the this OC of the PS Basar have submitted his report that there's every likelihood of possibility to breach any kind of moment. That's why this 145 CRPC is invoked by the executive magistrate. So there's nothing wrong in invoking this at that particular time.
No, that page 16, which the additional PP has referred to. This order has been passed and set aside by this honorable court.
Yeah, Lordship, this is the Lordship.
This, I'm furnishing that copy, order copy of this court.
16.
Page 16 has been passed and set aside. By order dated 03/02/2021 in WPC number 462 AP 2019.
Page 16, 16.
Yeah, which C has referred to.
Yes, that is a Keba decision.
Kaba decision,
Yes,
Kaba order,
Keba order.
Kaba order for conducting of the Kaba. And this has been passed and set aside by this honorable court 03/02/2021.
02?
03.
Where is the order?
My lord, I'll furnish this. I have in the soft
Lordship,
copy.
after this order, Lordship, this 145 was invoked. And later state this may be past, Lordship, that is, I have no concern about that. I'm just concerned about 145. At what stage this has been invoked by
fine,
the
but,
issue magistrate?
You are done with your submission? Done? Then I have my rejoinder. One thing, the scope of argument has traveled to section 107 of maintaining peace and tranquility being
Like
there for.
Wonders.
Yes, this is not the correct proposition to include with the parameters of 145 law. And then number 2 will only concern is only that it is a private dispute. No public peace and tranquility, no hearing, no notice, nothing. He cannot. Yes, that judgment which I have placed to judgment, that will apply.
Yes, right.
Yes, sir.
Okay, so-
And-
Okay, pass the order.
Yes, sir. Great.
That will be disposed of.
Yes.
At the stage of admission, I think.
Yeah, admission to, there is no bar for disposal.
Of like.
This is the. Anything? Item number?
16 Lordship, bail matter, Lordship. Yesterday it was
16.
bail Lordship, it was pending matter. Bail matter.
Big. Yesterday's matter, no?
Yes, sir.
You've gone through the,
Lordship, I've gone to the, this LSA record, Lordship. And Lordship, as per the LSA record, it's prima facie well established, Lordship. There's a very heinous crime, Lordship. And Lordship, the trial is going on full swing.
his name is not mentioned.
Lordship,
Yes.
Lordship, name is not mentioned, but Lordship, the statement of the accused as well as the core accused, his name is there, Lordship. They have mentioned his name, and Lordship, during trial also, Lordship, there many other witnesses also there, Lordship, only for the PW
Any allegation
investigation.
made by the four witnesses.
Lordship, because this is chain of event, Lordship, because they have order, they are together, Lordship. It's a group killing, Lordship. They are, Lordship, the pre-planned, Lordship, murder. And Lordship, this main accused, his statement, Lordship, clearly stated that with him, the other two accused, they were together, they have planned that night to murder that deceased, Lordship.
Except
after
this-
execution of-
Except the statement of the, on the basis of the statement of co-accused, he
Law
was
sir.
arrested.
Lordship. Lordship, because the trial is just begun, Lordship.
Yes, yes, yes. There is no eyewitness, then nothing is there.
Lordship.
But anything except this.
Lordship, forensic report is there, Lordship. Fingerprint report is there. CDR also been recorded, Lordship.
Fingerprints.
Yes, Lordship. It is there, Lordship. This is very crucial, Lordship.
Please.
Lordship, can I submit 1 minute, Lordship? In this case, on the last occasion, Lordship, police has submitted that I am the main accused in this case, on the last occasion, Lordship. Now it comes out in the case that I have stated in the last occasion, Lordship, one of the co-accused is Akram Hussain, Lordship. From that, Lordship, my name comes out in this case, Lordship. Now, depending on the statement of the 161, again, the one thing comes out in the last occasion, Lordship, in entire of the 4 witnesses, whether my name comes or not, Lordship. Then I stated that, Lordship, only the name of the one of the accused, one of the witness, Lordship, identifies Saddam Hussein, that I know him because I am also lending money from him. Only these things, you know. Now, Lordship, the thing comes out. On last occasion, I started by having a 527 is the length of detention. Only thing is that, then what is the time, Lordship, for filing a bail application in the court? Only having a section of 302 and 201, Lordship, from long time. And I'm not going to say that, Lordship. I'm only saying if any condition, my submission was that on the last occasion also that, Lordship, if 4, 5, 6, near about 10 witnesses
Second
left.
bail application.
Second bail application, Lordship.
Last was rejected.
Yes, Lordship, for the initial stage, no any evidence were examined in that.
Rejected by This. court.
This court, Your Honor. Lordship, here,
Which court? Which one?
I have annexation order.
Where is it?
Yes, Lordship. On page number 18, Lordship,
Page number?
18, 18, Lordship. Now, Lordship, in this case, already the 4 evidence also examined, informant also examined, charge already framed, Lordship. Thing is that, Lordship, only to comes out whether I am appeared in the trial or not. Only having objection of this, in this case, Lordship. So, Lordship, conditions of
There is notification in our high court that the order, that the bail order who earlier rejected by the magistrate or by this judge, concerned judge, he is to file the second. He is to
In the
file
same
the
court,
second-
Lordship. Yes, Lordship.
Same court.
Lordship, here the thing is that,
You
Lordship,
can take the advantage of opportunity to visit video conference.
yes, Lordship.
Otherwise it is simple.
Lordship,
And
the
Lordship,
thing is
this
that,
is there,
Lordship,
Lordship. This I remember, Lordship. That is there.
yes, but Lordship, my submission is that, Lordship, yes,
I
if
have
in
no
the,
problem to
Yes,
pass
Lord.
any order, but there's a notification
Lordship,
of our
Lordship.
high
yes,
court.
Lordship.
Recent notification of the Honorable
Chief Justice, Lordship. Yes, Lordship.
who has rejected, only in case of rejection, who has rejected earlier, he is to take up the matter.
Yes, Lordship. That is, here, Lordship, the thing is that it is not the motion. If the case would be submitted in the same court, Lordship, then it will be in the motion period, Lordship. Now the LCR is there, Lordship. But-
Is there no
yes,
problem?
yes, Lord.
Through VC also,
Yes, Lordship.
I'll take one matter tomorrow through VC. This, because of this type of problem. The
Okay.
earlier that was rejected by me,
Yes, Lordship.
and that is why I'll take up the matter on tomorrow. And this bail application only on rejection,
Lordship.
in case of rejection. Then Sahabuddin,
Yes, he's the father, Lordship. He's wrongly printed there.
father.
He is the Lordship.
This application is preferred by the accused Ramjan Alam. Same person, no? Same
Yes,
person.
same.
This is the problem. So, you can tell this registry of Das or anybody else can be.
In the causes also, their lordship mentioning the name of Shabuddin and the state lordship.
And today itself, it is person no problem at all. Because city is there, no problem. So if you can pick up the matters for basic. Today itself, no problem.
So Lordship, this matter may be listed appropriate bench Lordship.
Yes. I told the registry any person, you can matter, if possible. Today, because city is there, everything is there, so you can take up the matter today itself. Because you have a problem when, because you are from Guwahati, no?
Yes, lordship.
So you can move before Guwahati also, no problem, this is Rabin Gopal.
But you only having the urgency that lordship, I have submitted one death certificate that lordship.
Yes, yes, I can understand, but this is the problem. This is the order of Honorable Chief Justice, written order. So nobody is coming? That's why we will never know. We used to be reject police and open open. So. No, true, receive for the receive. More clear than that, receive for it. Because they give to order separate order for you. So, apne. So you can talk to the registry. They'll help you. So you can move before the Guwahati High Court also, no problem, in the principal bench.
Yes,
No problem, because it's a recent notification of Honorable Chief Justice, I cannot move.
Obliged, lordship.
Problem. 17.
May I submit, my lord?
Yes.
Yes, my lord, item number 17 and 18, my lord.
17 and 18.
18 is from same FIR, my lord. May I pray, my lord will take up item number 18, my lord.
17.
I would pray, my lord,
430.
same FIR, my lord.
430. 2 persons.
2%, my lord. I would pray, my lord will take up item number
From the
18, my lord. 18, my lord. 18 is there, my lord.
anybody from state.
My lord, I am into his coming, my lord. I'll just, my lord, before going to FIR, my lord,
Wait for some time. Presence of state council is required. PP or additional PP, anybody?
yes, my lord, he is here, my lord. May I submit, my lord? Before coming to my lord, FIR, my lord, I will inform my lord, this present applicant, my lord, is serving as a deputy director, my lord, school education, my lord. He is at the bars of his retirement, my lord, is about 60 years, my lord. And additionally, my lord, kindly note, my lord, in this case, my lord, the offense, my lord, maximum punishment prescribed is 5 years, my lord. Now, I'm indicating that, my lord, to satisfy that here, my lord, it is a case under the necessity, my lord, of section 41A, my lord, CRP is requirement.
447 IPC, that is a bailable.
Bailable, section
Section
3 of PDPD, that is, my lord, prescribed punishment is 5 years, so this is non-bailable, my lord.
3 years or 5 years.
Extended up to 5 years.
5 years.
5 years.
May I invite kind attention of my lord at page number 19, my lord. This is annexure number 1, my lord. This is the FIR, my lord.
Page number?
19. Annexure number. The written FIR, my lord, will find at page number 22, my lord. I will read 22, my lord. Now, additional, my lord, one thing, my lord. This is cross FIR, my lord. Cross FIR only, my lord. I am reading FIR, my lord. Subject FIR, subject page 22, my lord. Subject, my lord.
Yes.
FIR against Sri. This is me, my lord. Sri. And Sri. Second is, my lord, the applicant in the item number
17.
7, my lord.
Okay.
See, for damage the public property of government higher secondary school boundary wall and committing the offense of giving false information, my lord, to the police and doing wrongful restraint during the time of official lane verification 17 August 2023, my lord. Sir, most respectfully, we have the honor to inform you that on date 17 August 2023, we the undersigned who happen to be responsible citizen of Alo area have visited the government higher secondary school premises to make verification of the area after receiving various complaints of the land encroachment of the school premises. It is pertaining to mention herein that we have visited all school premises of the government higher secondary school Alo, and we have also visited the area of Sri. This is me, my lord. After receiving a circular from the land revenue and settlement officer for joint verification of the school boundary and encroachment area, and there are nothing illegal in our part because everything was done legally. But Sri Sasan, my lord, has misled the police station all by giving false information to the police, which lead to register of false criminal case against Alo. My lord, kindly notice, my lord. Alo PS case number 44-223 under 44-7. Now, my lord, you kindly appreciate, my lord, on the report, my lord, this FIR, my lord, the present FIR where I am praying is a cross FIR only, my lord. FIR, this a cross FIR against my FIR that is Alo PS case number 44-23, my lord. It is also pertaining to mention herein that we have never made any trespass and our visit was fully legal because after obtaining a circular from DLRS for joint verification, we visit the area. But we have made as a criminal and accused by giving misleading information to the police. Therefore, your good office is highly prayed to register a criminal case against Sri such and such for giving false information intentionally and restraining the official team, including us. That the another offense that committed by the such and his power is we have damaged public property at the school boundary. Government has seen school all illegal encroach the school land and damaged the septic tank of the quarter number 617. The Sir Sekato has lost and FIR against us to seal the above mentioned offense that have been committed by him and his father.
So who lost this?
Also the subject, my lord. FIR against Sri Sas and Sas, my lord. Sas and Sas, my lord. This person, my lord. My lord, I'm indicating this.
First, who lost the FIR against this?
Yes, my lord. In this, my lord, correctly noted this. With respect,
Prior to that, he lost the FIR.
my lord,
But present petitioner lost the FIR.
we lost
That-
lost the FIR on my lord 18 August, my lord, 2023, my lord. 18 August, my lord.
18 August.
18 August, my lord. Register FIR, my lord, will find a my lord will kindly turn to page number 31, my lord. This is I was in the reading the written FIR, my lord. To register FIR is page number 31, my lord. Our FIR, my lord, was registered on 22/8/2023, my lord. Now, dear FIR, my lord, the annexure number 1, my lord.
30 August.
My lord, or 30, my lord. Now this is in some instruction, this is cross FIR only, my lord.
Subsequent FIR.
FIR. Now, my lord, other aspect of the matter, my lord, kindly I'll indicate one thing, my lord. Page number 25, my lord.
25.
My lord. Starting from 24 only, my lord, 24. This is land allotment in favor of my mother, my lord, by the competent of the government of Arunachal Pradesh, my lord. This is my mother, my lord.
The land.
Land, my lord.
Land
Land
and
allotted to
house.
my mother, my lord. And now this land has boundary with the school boundary, my lord. Now they are alleging, my lord, we have encroached, my lord, some land, my lord. Whereas, my lord, will kindly turn to page number.
Yes, Mr. Pipi.
My lord.
I pray, as I am praying for entry, my lord, this person, my lord, is arise from cross FIR and particularly this is all is person, my lord. Otherwise, my lord,
But you have to appear before the IU within 7 days from.
surely, my lord, my lord, I will, my lord.
Parts one, so, okay, the other one,
Other one, my lord, same, my lord, this is son, my lord.
his son,
Son, my lord, his son, my lord.
son of this petitioner.
Petitioner. And son is the past, who lost the FIR, my lord, against those person, my lord. And about the merit also, my lord, if kind, my lord, give me a movement, my lord, 1 minute, my lord. I from the report, my lord, I indicate, my lord, there is no cases at all, my lord. They have just lost, my lord, cross FIR in a vengeance, my lord.
And bail application 59, 59/23. Third witness Rancho, learned counsel for the petitioner, learned BP is appearing on the stage, responding. The petitioner has preferred an application until 38th CLBC, seeking pre-arrest bill, who is apprehending arrest in connection with Allo base case number 49/23 under section 447 IPC, read with section 3 of PDPP Act. PDPP Act. What is the full form? Prevention of
Prevention of damages
damage
to
to
public
public
property.
property damages, no? Then
Prevention of damage to public property act.
in bracket PDPP Act in subsequent. It is submitted by learned counsel for the petitioner that the petitioner already retired or is.
At the pass of retirement, my lord,
Already retired?
not my lord, pass of
Going to be
retirement,
retired.
I have still serving, my lord.
60 years old.
Yes, I was not 60, my lord, by this year I will retire, my lord.
He will be
I
retired.
will.
He is about to retiring from his service. He is presently serving as the deputy director,
The present yes, deputy director,
school education,
my lord.
school education, around 60 years of age. In the office of Directorate
Yes, my lord.
of Secondary Education,
My lord.
Itanagar. It is further, it is submitted. Further submitted that prior to lodging of the FIR against the present petitioner, the petitioner had earlier lodged an FIR against the informant of the FIR that they had trespassed into his residence, no?
My lord.
They had trespassed into his residence. And threatened to kill him. And subsequently, the present FIR. And on the basis of, prior to that, on the basis of the said FIR, a case was registered No any case was registered?
Yes, my lord. It is page number 31 only, 31, my lord. Can you see 31, my lord? 31, my lord.
3-1.
My lord. Okay, all of PS case number 44 up to 2023, my lord. Under section 447-506. 31, my lord. 31.
31.
Case number is, my lord, FIR, all of PS case number 0,
Allow this case number where it is written. at the Bottom or top of the.
page number 31, my lord. It's serial number 1, my lord. FIR number 0044, my lord.
00.
44. Dated.
IUPS case number 44/2023 under section 447/506 IPC. Subsequently, the informants have lost the case against the present petitioner alleging of making a false allegation against him that he has damaged the government property, no? Secondary repression, alone. And an additional PP. If you have objection or no objection.
My lord, since I was about to make a submission, since the purpose of 3438, in fact, is to protect those against whom a false allegation has been made. But apparently there is a certain allegation in the FIR. But considering the fact that the accused is more than almost 60 years of age, my lord, till returnable date, my lord.
So that may interim free arrest.
Yes,
That may be considered.
Yes,
On an additional PP, and sorry, PP, Mr. PP has considered, submitted that. Considering the nature of the offense, the interim free arrest will be granted to the petitioner till receipt of the case tag.
case time.
So considering the submission of learned counsel for the parties, it is a fair case, I think, to grant free arrest well to the petitioner. 10,000 rupees with the conditions so and so. Is to appear before the aisle within 7 days from today and some other conditions.
Fixing this matter on 22nd.
Yes.
22nd of this month.
Call for the case
Case
time.
time.
22.
22.
9.
My lord, may I have the same order can be passed in the, my lord?
This is something. Is that just.
Repeat.
Highly available.
Yeah.